Can people hear me? Is that working? Is it a bit quiet? Okay.
I feel very tall.
Yeah. Okay, let's get started. If you're asking yourself if you're in the right panel, the answer is yes. No matter what you're looking for, because we are talking about four extremely important countries worldwide that actually combine almost half of the whole population of this world. So just to kind of show how important these countries are just from an economic perspective. We will go through the panel and do a short introduction. Just want to kind of lay out what we want to do today. There have been rumors that just by attending this panel, you are qualified to practice law in all of these four countries. Not correct. The idea is really to give you a quick overview of these countries and some of the legal issues that are new, some of the things that you might encounter when you deal with them. In the end I think you all know that if there's anything really coming up that you have to kind of deal with in these countries and it gets serious, you need to have professionals involved. So it's really given the first overview. We'll talk about some of the latest developments, some of the specifics of these countries. What we would like to do is keep time at the end of the session for questions and answers, but also kind of want to hopefully give you some sort of little cheat sheet at the end of what should you remember when you think about these countries? What should you remember when you talk to the professionals? Some of them might be actually here on this panel if you look for advice in these countries. So that's sort of the overall goal. So I'm Oliver Bream. I will moderate this panel today. I've been working several years in e-commerce. Have been on at this conference a few times. Actually went also to the school here. But let's kind of start with introduction. Shana.
Oh, I'm first. My name is Shana Tomaszewska. I'm a corporate IP and IT lawyer. I also do a lot of e-commerce for our clients based in Moscow. So we advise quite a good range of Russian companies on their Russian and international operations, as well as we advise some multinationals on their operations in Russia. So I hope I'll be able to give you a good overview of what's going on there.
Hi, I'm Nikhil Narendran from Trilegal, which is a law firm based in India. I am based out of Bangalore. So I lead the practice, which is TMT, Technology, Media, and Telecommunication. I also advise a lot of e-commerce clients. I am both a tech transactions as well as a tech regulatory lawyer.
My name is Timothy Ma. I'm a senior legal counsel and director at the Tencent Legal Department. I look after Tencent's international products and expansion, including privacy, payments, and whatnot, and some other corporate matters. So yeah.
Okay. My name is Rafael De Cunto. I'm a partner at the Pinheiro Neto law firm, a Brazilian law firm, and I'm based in São Paulo. I'm in the technology and corporate group.
I'm Dan Doherty. I'm a senior director with Alibaba Group. Before that, I was the general counsel of Monster Products and have experience with working at eBay and Yahoo as well.
Great. Jenna, let's start with Russia and what you can tell us about some of the latest developments in the data collection law, also some of the quite frighteningly named tax on Google initiatives that we're seeing in Russia.
Yeah, well, but there were some developments recently, but before I can jump on this, I just want to quickly mention that Russia is a civil law country, so unlike the US, we have a civil code which governs everything, and e-commerce was largely governed by this civil code. So we didn't have any specific laws or regulations till recently. So, and in the last, I'll say, 2 to 3 years, we have a lot of things changing. So in terms of tax regime, we have a new tax on Google imposed, which is not quite as a normal Google tax, which is imposed across Europe. So we're mainly trying to apply VAT to services provided by multinational companies in Russia and to Russians. So before that, it was believed that multinationals had an undue advantage because Russian service providers had to pay VAT, whereas international companies didn't have to. So now from 2017, everyone is in the same position. And interestingly, there were discussions as to whether multinationals will comply or withdraw. And now we can see that most of the companies are complying. I just checked quickly how many companies are registered for VAT now in Russia, and it seems that all major players are covered, like Google, Microsoft, and the others. So even LinkedIn, which is blocked in Russia, they submitted their registration. So, and except for those changes, there were a few important corporate ones, because our civil code, which was in place for 20 years, didn't actually address properly e-commerce issues, because when it was implemented in 1994, no one knew anything about internet. So, and the good news is that there was a major change into the legislation in 2014 and 2015. At least we now recognize electronic documents. There are some improvements as to recognition of electronic signatures, and also there are some developments on personal data and personal protection law. I guess we'll discuss personal data in more detail later on, but what I want to mention is another significant change. We have a very specific personal data storage law, which came into force in 2014, which requires all the data, all the personal data on Russian citizens to be stored in Russia. And again, it created a lot of hassle for multinationals, because they had to somehow identify the users, and unfortunately the legislation wasn't clear, and no one was sure how they are supposed to identify Russian citizens. And then they had to store all the data in Russia. And again, there were discussions why it was done, partially probably for data protection, but mostly for data collection, to make data available to relevant government agencies. So, but now we can see that there are still a lot of things which are unclear, but it's developing, and multinationals are trying to comply. So, and the only big issue which came, which happened this year, it's that LinkedIn, they didn't comply with the laws, and they were banned in Russia. So it created a lot of negative publicity. But the bottom line case was that they didn't want to store the data in Russia. So everyone is expecting that they will comply soon and will come back to serve the client and run their business as normal. So that's it, I guess.
Great. Raphael, since the bad word taxes was already mentioned, I understand there has been quite some recent developments in the area of labor and taxation in Brazil.
Yes, indeed. When it comes to labor, Brazil is famous for its old-fashioned laws that were set up in the 1940s. They were fashioned after Mussolini's own law. And they're very, very protective of employees. Employees have very easy access to courts once their contracts are terminated. It's absolutely common for them to go ahead and sue the company to do that. So you see large companies with sometimes 1,000 lawsuits against them. And on top of that, compliance with labor laws is very tough because it's so heavily regulated. It's very easy, actually, to make some mistakes. So, and you're going to see later on that the bill you have to pay is huge. That is a key factor, actually, in due diligence when you're looking into a company to buy. But since we have been in a recession for the past 2 years, the government has really now, it appreciates that some companies that are in difficult economic situation will have a difficult as well in dealing with how to comply with so many laws. And they have been pushing for reforms in the labor area quite hard. One thing that has already been passed and approved by Congress is a law that allows the company to outsource all its functions, which was not permitted before. And now there is a set of about 100 changes to the labor laws. But the most important change, and this is a bill of law, actually, which is going through the legislative process. The most important is that the company and the employees not necessarily with the union, but the employees of your company. They can get together and resolve on things that would overrule the laws, the labor laws. So you can find solutions that are very well suited to your company in order to make it survive and preserve the jobs. I think that's the key take there. So that's on the labor front. On tax front, this is something that on the tax front, Brazil is really for professionals. It's very complicated. So that you have an idea, we are a large firm, and as opposed to the U.S., our firm has a very large tax practice. And it's not only tax advice, it's tax litigation. So we have like about 100, I think, 100, 150 lawyers just dedicated to that. It's a huge practice. But that's how things are. There's been some advances. There is a move toward making things more simple, which by itself is a great advancement. But the thing is, the tax authorities are very, very aggressive in collecting taxes. You have to be very careful about what you do. You have to be very careful about who you hire to do your books. But I'll leave that for the takeaways. But for changes, besides the push for a reform, which is out there, but we don't know if that's going to happen because politically is a big issue because it affects the revenues of states, cities, and the federal budget as well. And all this is divided and set in stone in the Constitution. So in order to approve any amendments, you have to have a high number of votes in both houses of Congress. But the changes that are kind of out there, recently the government adopted a tax amnesty in order to provide some relief to those that are in distress, and there are many of those. Certain tax breaks are being terminated, and now there's been talks about taxing dividends whenever they're paid out either in the country or inside. Dividends are taxed at a 0 rate, and that may change, but it's not out there. The only thing that I'd like to really highlight very quickly is for tech companies. There's been a change in the legislation last year that will require further regulations to be adopted by the cities, which is a tax on services. There's been a lot of dispute whether certain businesses that are conducted online, for example, streaming or software as a service, cloud computing, would it be taxed as a service, and which is taxed at the city level? Ad sales, for example, would it be taxed as communication? That would be at the state level. And last year, there was this list of services that actually belonged to the city to be taxed. So law was passed, but the cities have to issue new regulations. And so maybe tech businesses that would do something in a certain way may have to change a little bit in order to adapt themselves and hopefully pay a little less tax.
Right. Talk about regulations. Then can you give us an overview of sort of the e-commerce environment that we see in China today, and I think especially some of the notice and takedown procedures and laws?
Well, I mean, I think one thing that people should be aware of, earlier this year, there was a draft e-commerce law that was circulated. There was a comment period, actually, I think from late December the 27th, I think, for a month until January 26th. And it's intended to be a comprehensive e-commerce law. You know, as you say, you know, a couple of provisions of it specifically deal with notice and takedown provisions and protection of IP. At least the draft language. So there's a comment period. The standing committee for the Congress now has taken that draft language, is considering that in the comments, and will come out with final language. There's no scheduled timeline for that to happen. I think it's generally anticipated that their next steps or their announcements will happen within the next year, probably by the end of this year. When it would go into effect or be enacted, I think, is a separate issue. But it provided, I think, for what we in the U.S. would be, at least the draft language provided, sort of a not completely foreign sort of notice and takedown process. It anticipates that a rights holder would make a platform aware of where the infringement can be found, provide some contact information for themselves, and then it obligated the platform to provide that information to the seller or the user who's been reported as infringing. And then if there's a counter notice, it seems to contemplate that the platform would make the rights owner aware of that and step out, and it would require more formal action by the rights owner to continue to pursue that. Not entirely dissimilar from what we see with the DMCA. If there's a counter notice and once the period expires, there's a limited window for a lawsuit.
Great. Nikhil, one of the things that I read about, which sounds very interesting, is new developments also in India, especially around personal identification. And if you can tell us a bit about that, that'd be great.
Yeah, so I think the whole landscape in India is sort of changing with respect to e-commerce. So till very recently, there was a lot of confusion as to what you can do in e-commerce. So what the players used to do was the companies like Flipkart and Amazon and Snapdeal, the major players, they used to operate this model called marketplace model. So essentially, they were not really selling products because there used to be restrictions on companies with foreign investment selling products directly to consumers. And there's a lot of, so what these companies were used to do was they used to just say that we are marketplaces where third-party sellers could come and list their product and sell the products. And then it sort of, then it became a big issue in the sense that the brick and mortar retail stores had an issue with respect to the deep discounts that they're giving. They came out and said, look, the government is to step in and do something about regulating them. And the government very recently clarified that these marketplace models are okay and they can do marketplaces provided that they don't have any super sellers. So in the sense that there cannot be any seller on the store with more than 25% of the volume to do that business. And they also said that you need to ensure that you don't control the pricing of the products which is on the market, and you also do not control the inventory or on the inventory in those marketplaces. So it's actually become regularized in the last 1 year or so in the sense that there's a lot more clarity for doing business in India in the e-commerce sector. And very interesting point that Oliver also mentioned to sort of link the sort of loop here. So there's a new development in India which is an identity project which is run by the government. It's called the Aadhaar project. So this is arguably one of the biggest identity projects in the world, in the sense that India has a problem of identity, in the sense that 1.4 billion people, a large number of people in India, do not have a driving license or a social security number equivalent to go and claim government benefits from. And as a result of this, it was estimated that every year there used to be at least 70% leakage in the subsidies which is given out to various people in India. To sort of close the loop, what the government did was they came out with this identity project called Aadhaar. And it used to take every person's biometrics, which is your 10 fingerprints plus your iris scan, and then give a unique ID to a person. So now we have got around 1.2 billion on this whole system, and it was just used to prevent leakage of subsidies. Now what's happened is government has said, look, now there is a lot more potential of this whole system. So how it used to work is when I used to go and get, let's say, a cooking gas subsidy from the government, I used to put my fingerprint and then say that this is me, this is my ID, and I am the person, so give me the benefit. And the government used to give me that. So now government has created something known as an API layer over this and has opened it up for private parties. So how that sort of works is now you are able to make banking. So this Aadhaar number, which I've mentioned about, which is linked to your unique ID, is essentially become your financial address, so to speak. So you can make payments using your thumb impression. You can initiate a payment using that. What you can also do is you can avail a lot of benefits, not just from the government, but also from the whole players in the e-commerce sector. So many players are now examining the various possibilities in which Aadhaar can be integrated into their e-commerce system and how it can be used to identify a person, to prevent frauds and even initiate payments in the system. So now, while we are doing this, one of the key challenges that sort of comes attached with it is, of course, the privacy. Because privacy is, we're looking at 1.2 billion data, fingerprints, iris scan, all biometric information and related information on the system. And look, Indians as a community, we are not generally that private, so it's really been spread around. So the data is like really leaked around, so there's no real control over it at the moment, so to speak. And there is a lot of push on this from the government. So there are two matters before the Supreme Court currently which deals with privacy, and government is pushing forward a privacy law. And this is where it gets interesting. So the current privacy law that we have is sort of similar to what we have in most advanced jurisdictions. We have a consent-based mechanism for sensitive personal information, and a PI or a personal identifier information is much more of a choice-based, where you can just need to inform the user about what to do with the PI collection. Now, there is one school of thought which believes that we should have a strong, robust privacy law which is based on similar principles like you see in the States and also in the EU. There's also a very different school of thought which has sort of come up. I'm sure some of the privacy advocates will have a problem with the thought itself. So the idea is to do away with consent itself. So in the sense that the question is consent outlived its function, so outlived its utility? Because in a big data world where a lot of information is collected from the user, the actual consent which is taken from the user is giving without reading the terms and conditions or the privacy policy. So what does consent finally serve? So it's a thought process where, it's a very different, even I find it very difficult to sort of digest that as a concept right now, looking at various privacy laws that we have across the world. But the concept essentially is that instead of a personal rights-based system, is more like a rights-based system which is based on harm's principles, and saying that you're free to collect data, but a set of guidelines as to how you could use the data. And finally, if you harm a person in any manner, then a very strict compensation to that person who's been affected by such an act of the corporation. So that's the essential. That's a discussion which is happening in India currently on privacy, and I think maybe next year by this time we should have a very maybe a different law altogether to deal with privacy in India.
Great. So we will get back to the privacy topic in a moment. But Timothy, since payments were mentioned, would be kind of interesting to get your perspective, sort of the general legal issues when it comes to payments in international environment.
All right. I'm not sure if the audience knows who Tencent is. Anyone knows Tencent's products, WeChat? All right, very well. Not bad. Okay, I'm pleased. So in China, Tencent office is huge in terms of payments, along with Alibaba. So we see a lot of various issues in relation to payments, and I think same with Ali. We were both trying to expand internationally in terms of our payments business. So I think the current laws are typically lag behind innovation. That's the key issue. So whenever we launch our payment service overseas, we'll need to sort of try and find how our business or how our operations will fit into the current legal framework. Most of the time, the legal framework, they try to govern banks, they try to regulate financial institutions. Not for us, not for internet companies that offer financial services. So this is one of the issues that we see. So what I think is key is to engage with the regulators as early as possible. A lot of the countries, when you're talking with the regulators, you see that they actually encourage fintech developments. They encourage that we go into their markets, help them to go cashless, help them to develop the fintech industry. So most of the time they welcome us, but obviously they cannot say, okay, you can disregard or whatever law that's in place. So engaging with the regulators, get their consent, get a feel of what they think is important, I think. Secondly, on the payments issue, obviously privacy is an important issue of both the use. Well, when we launch payment service in different countries or in China, we obviously would have access to a lot of information, not only personal information, but also financial information. Those are important information for internet companies so that we could do proper analysis. So how do we comply with different countries' privacy law is an important issue. So I think those are the two major issues in relation in international payments. Obviously, there are AML issues and stuff like that, but in love the time, I'll just focus on the first two.
Great. Yeah, since we kind of talk about the privacy part, Rafael, can you give us sort of an overview of the situation that we have in Brazil right now with the developments in privacy, and what people should expect and what people should keep in mind?
I think that what people can expect, the most important item is that there's a privacy bill being looked into by Congress. It was introduced and would advance lots of items that were addressed in the internet law that was adopted in 2014. It is, as with many of my colleagues here and with the BRIC countries, there's a lot of uncertainty. And there's a lot being developed. Last week and today we had sessions at the Brazil Supreme Court debating. That was prompted actually by the judges, the Supreme Court justices, because of certain lawsuits that were filed and that have constitutional matters. But one is discussing if it is constitution under the internet law to suspend, to block the service. And that has happened before in 2007, 2012, 2016 with YouTube, Facebook, WhatsApp. Is that a constitutional way of dealing with one particular problem? And that particular problem generally is contempt of court. The local Facebook company, the WhatsApp, who is part of Facebook, or Google, they refused to deliver certain information that was ordered by a judge to be disclosed in order to identify somebody or to take down something. And the penalty that the judge adopted was take down the whole service, and it did. Is it proportional? How would it affect other things? For example, the access of people to that service. Is it a reasonable measure? This is one of the things that is under debate. And the other one is the right to be forgotten. This session would actually occur today. To what extent the right to be forgotten is your own private right versus a public interest to have something recorded. So these are things that are still going on. It's funny because if I could say something is the laws in Brazil, they end up changing because of certain facts. For example, there was a law that explicitly provided for hacking being a crime, was prompted after an actress got her pictures taken. The internet law itself, when it was passed, it was actually pushed in very fast because of the Snowden scandal, that the Brazilian president had been snooped by the American intelligence agencies. And at that time, we almost had adopted data localization obligations.
Jana, you mentioned already some of the important privacy laws in Russia that had a pretty interesting impact. You can talk a bit more about that.
Yeah, sure. Well, generally, we do have personal data protection law in place. And as I said, there were major changes in 2011 and 2014. The law imposes a few obligations on the personal data operators, And there are, of course, personal data operator may only collect and process data with the consent of user. And this, of course, is a very difficult concept for a legal system because it's unclear how the user can express its consent, especially given that till recently we didn't have any regulations with respect to electronic documents and electronic commerce. So the courts were they didn't know how to approach the consent, whether the user clicking something would provide would it provide enough information about the user consenting to something, and also it's connected to the issue of electronic signature. So at which moment the courts will say that, well, this person consented to something, and the law imposes very strict obligations on how the person has to be identified. So actually, first, before collecting consents, you have to collect a lot of personal information on that user to identify him or her. So, and it means that in order for this consent to be received, you have to go through certain identification process first. So, and in practice, it's now realized through personal pages or through verification through SMS or phone or otherwise. There are still opinions that good old written consent is the best thing, but apparently it's impossible to collect written consents physical from all the users of the internet, so it's out of the question. We can see in the recent case law that courts started to tolerate virtual or electronic consents if there is enough information on that user. Right. Another question which is bothering everyone now is what is actually personal data? Because of course all the rules apply only if you are processing personal data, and again the definitions in our law are broadly based on a Strasbourg law of 1981, which isn't very helpful because it didn't go into much detail in describing of what personal data actually is. Well, it's clear that it's something which will help us to identify a particular person, but then the questions are arising whether an email address or an IP address or a telephone number itself can be personal data. So, and now we know for sure that a nickname of a person, of a user, is a personal data because there was a major litigation 2 years ago in Russia when the biggest telecom company, telecom service provider, it collected information about telephone numbers and physical locations of users and passed it over for an advertising campaign. So, and the court said that, well, telephone numbers and nicknames together are definitely personal data, and it's clear that nicknames, standalone nicknames, are personal data. We're not sure if under Russian law just a telephone number or just an email address would constitute personal data, but if it's connected with some other information on the user, like address or IP address or something which will help to identify him or her, it may constitute personal data. So I understand that from our early discussions that in Europe it's very clear that all such things are personal data, so there is no speculation on that. In our cases, I can just see how businesses are trying to avoid regulation at this moment, just to by depersonalizing data. So they're trying to erase like certain details and pretend that there are no personal data operators. And most of the companies are now playing with this concept and seeing where are the boundaries, because there are no clear identification from the lawmakers. So that's about the content. Another issue is that requirements. Why is it happening? So we have vague concept or vague notion of personal data on one hand, and very strict and very burdensome regulation on the other hand. because to comply with it will require a lot of costs, a lot of time, and most of the actions can only be performed by specialized licensed agencies. So it's definitely will cost business a lot. So therefore, now the market is trying to figure out how to either avoid the regulation or comply. And another problem with our personal data legislation is that it's silent, and no one really knows how the compliance looks like. There are no clear indications on how to comply with it. So at present, I'd say that it's a major concern of all e-commerce businesses in Russia, because they're receiving a lot of data, and the most conservative ones are trying to be over compliant, because till the major precedent, no one will know if depersonalization will work or not. So that's the general landscape. And again, storage. As I mentioned before, all personal data must be stored and processed physically in Russia, which creates technical complications. And also there is a discussion on whether data collected in Russia can then be stored somewhere else, because sometimes companies, they may want to have backups of this information on international servers. And the legislation is unclear. Recent statements from authorities show that they don't like the idea of personal data of Russian citizens being stored somewhere else. So companies are trying to circumvent this by creating backups through, using foreign service providers or something. When you get a signal and then something is stored along the way accidentally. But generally, if we apply the law strictly, then you can't process this data outside of Russia.
One thing that I always kind of find interesting is I think for a long time there was really the different legal system was sort of silos, and every country was sort of developing its own. But I think every lawyer who hears anything what you say today knows that these are the same problems basically everyone has. So from my perspective, that's really a question for everyone on the panel, is looking at the country, kind of think about where are they most looking at when it comes to new laws? Is there a strong tendency to kind of create really their own regime? Is it really an idea to kind of look at maybe the European system for certain things or the US system? What are sort of if that can be said, what is sort of the guiding factor in some way?
I mean, I don't know if I know of a guiding factor, but I do think certainly, that the countries are looking to other countries, in terms of what they've done, what's been successful and what hasn't. I mean, if you look at the e-commerce law, the draft that was proposed in China, I mean, there were parts of that I thought very much had been informed, by the notice and takedown and the DMCA that's existed here in the U.S. since, almost since '98, I guess, at this point. There were parts of it that I thought were sort of informed by the European approach with respect to commercial or business sellers and the amount of information that needed to be shared to consumers, that was visible to consumers, before buying online. So I do think that there certainly is an effort to look at what's been successful or what's been tried in other countries. I mean, I think a lot of the issues that were talked about here with respect to privacy, I mean, and this isn't an Alibaba issue specifically at all. I mean, I hear this and you read about this, very, very often with companies that are, and maybe it speaks a little bit to what Timothy said earlier about sort of laws lagging behind current practices. But, it's so much less expensive for data and information to be stored in the cloud that businesses want to move in that way. Obviously, they want to comply and need to comply with applicable laws. And, it's not always easy to apply laws that weren't designed with that sort of storage in place or, have cross-border implications.
Definitely. I think that we are always inspired by what other countries do. The privacy bill that is in the Brazilian Congress, it was definitely inspired by the EU. It has a data protection authority. obligations to notice, to give notice in case of breach, things like that. But I like to think that we react a lot to news. For example, the fake news. All of a sudden, there are 2-3 bills in Congress prohibiting fake news. What's that? Prohibiting fake news.
Well.
Yeah. So it happens. So I think that there is still a lot to be done in Brazil with respect to that. And we like to preserve a little bit of a Brazilian twist to those things. It's funny because you see how the whole world, discussing data sharing. And you cannot share data. You cannot transmit data. You cannot do that. And I have to say, my impression is that we don't really give that much importance to this as individuals. It's something that we hear about and we end up adopting. What Brazilians really do care about when it comes into privacy is if anybody's bad-mouthing you, smearing on social media, emails, that kind of thing. That's what really prompted the law to be adopted. The internet law, I mean, that the law had obligations of record keeping by those that provide internet connection, by the application services, so that law enforcement can go after them and see who was there, who visited, who posted, and everything else. So there's always a local flavor, I think.
Yeah, I think in China, there's no one uniform privacy law right now. The privacy provisions are actually scattered around different laws, mostly facing consumers, etc. So there's no one single privacy law. Mm-hmm. But then China is actually going towards having one unified privacy law. That's in the drafting stage. We are expecting to see it in the Congress in 2018 and then implementing in 2019. But then from what we've heard from the market or from what we see, it seems that they're looking into GDPR, EU law as the guidance. So it does seem that China is going towards that direction, trying to mirror what GDPR is doing. But then when you look at other jurisdictions, like in Hong Kong, being part of China, we actually look towards English law as well as Singapore law in terms of privacy law in Hong Kong. So I think what I want to say is different countries will look at different, other countries, other regimes, and fit them into what the industry is, what their government expectations are, in order to implement their privacy laws.
To talk from an Indian perspective, I would say that we have borrowed heavily from the West when it comes to laws, especially the UK. And to use an Indian term, we have literally copy-pasted the UK legislation sometimes to India, and some of the problems that we face as a result is also because of this copy-pasting. So now the approach is slightly changing. Like for instance, the one I mentioned about the privacy bill. The reason, we sort of realized that some of the problems that India faces is very different from the problems of the West. So now there seems to be a slightly more different focus towards, finding our own different kind of solutions. And some of the things which we have realized over years that the lack of privacy legislation, lack of a strong privacy legislation in India, so to speak, has in fact helped, at least from a business perspective, certain businesses to grow. For instance, I think one is the business of health technology, for that matter, the health tech. It is the kind of stuff that is going on in India right now in health tech, in terms of business intelligence and predictive analysis and finding out cures which will work in certain regions based on patterns, etc., is sometimes difficult to work with, and certain Indian startups who operate in this sector will not be able to foray into EU or US for that matter because of the strong regulations that you have. Whereas in India, due to the lack of regulations, they actually are able to do something more. Look, it's a question on question of whether it's beneficial to the consumer or not, but it has benefited the Indian industry to some extent, and we are seeing a lot of activities on these kind of space. So I would say we are slightly positioned in certain way, in the sense that we can take a slightly different path maybe compared to the West. At least it comes to certain things. For instance, privacy is one good example, and I would say payment is another one, because the kind of advancements that we've actually made in payments, in the sense, it is arguably one of the most secure payment networks that we have. We are one of the first to bring out with the second factor authentications. That's the OTP, the SMS-based OTP pins. These are the kind of things that's the India innovation in both fintech and financial regulations that we have seen. So I think we are slightly positioned to sort of take a different path.
Interesting. Well, I'd say that with a little bit of everything. Like in the course of a civil code reform, we took a lot of English law concepts on board because they were definitely beneficial for business. In terms of e-commerce specifically, I think we more look up to the US. And I have seen US cases being discussed in more detail, because now there is an e-commerce draft law. It's been produced and is being discussed, and chances are that it will be implemented towards the year end. So, and a lot of things were like borrowed or taken from the US experience. Even the case law is following US terminology. Like I've seen court cases discussing things like click wrap, even like written in English, so which looked very, very interesting, and still curious to know who that judge was. Very, very determined guy must be. So and also we have a national twist, of course. Probably it's adds certain political flavor to what is going on, because all the regulations are again aimed to get more transparency to government agencies, and also tax collection is a big agenda at the moment because of the economic downturn. Our state is looking inside and trying to collect more taxes. Therefore, information which is going to get is also used for tax purposes. Like one example, we have a new law for cash collection. For cash collection, so now all the devices which are printing receipts, etc., has to be connected to the internet, and they're also collecting data. So, and the users can receive their receipts via email, via SMS, or like in a standard form. It definitely simplifies online trading, but also it gives a lot of data on transactions to tax authorities, because the information is just sent directly to tax authorities. So therefore, it's like a mixture of everything. Having online cash collection machines is definitely following the best practices. Like, I bought this nice device 2 days ago, and I got my receipt on email, which is really nice. I don't have to store it, and I can forget about it. So it's definitely US experience was implemented. But then it's getting the national twist in terms of cash collection and in terms of getting more information to authorities. So it's more personal data protection on one hand and less personal data protection on the other. So it's a twist.
Great. Yeah, so I want to keep some time for questions at the end, but very briefly through the whole panel, some of the key takeaways, and that's important sort of for the audience. That's the stuff that you can bring up in meetings. Your bosses will love you. Your colleagues will hate you for that, because you might know more about these topics than they do. And so in some way, what is sort of 2-3 points what should be important for everyone, to keep in mind when it comes to the jurisdictions you kind of talked about?
I mean, I think, this is maybe more a career comment. Prior to this job, I worked for a consumer electronics company, and we had manufacturing. And for me, with respect to China, I would probably say 2 things. Keep in mind that for trademarks, China follows the first to file protocol, and so common law rights are not recognized. It's a matter of getting your application on file. So for in terms of enforcing your IP in China, know that get your marks registered, and Chinese consumers are not they're using Chinese characters, so you need a transliteration for your brand, and consumers will select one for you if you don't select one for yourself. And then the other issue I would say is just really paying attention to contracts. If you have partners, whether it's manufacturing or distribution or whatever it is, I've seen a lot of disputes that are really, they may come up as IP cases or whatnot, but really at their heart, it's more of a contract matter.
Well, I think that the first thing that we tell clients is, look, you have to have a good tax assessment of your business model, how it's going to work here, and how the flow of payments are going to work. And once you get to the right way of taxing your business, so let's make sure that all your contracts, your sales documents, invoices, marketing material, they are consistent across the board that would fit what you have elected. So this is one thing. Privacy, as I said, it's always a changing landscape. Be on the lookout for something that comes out of there. Another thing that I didn't mention, but you should also, as tech companies, I don't know what products you have, but we may see regulations in streaming, VOD, and games coming up in the next few years. Fintech, if you're into that, also make sure that you get good legal opinions about what you're doing, because for fintech startups, this is one of the areas where they like to spend some money, because they know if they do something wrong, they're going to go to jail. So they do spend money there. Just a couple of things more. First, good advisors. Don't be cheap. And I'm not saying just lawyers, but good bookkeeping companies.
I think the cheap and the jail kind of drop the
Yeah, that's a good message, right? Do that. And lastly, there's always a cultural thing. You have to appreciate that. Do some kind of due diligence. Try to meet people, how they are. Otherwise, maybe things won't work out. Things are essentially different in all these countries. Just to give an example, today's Valentine's Day in Brazil. There you are. My wife wasn't very happy that I'm here, but that's fine. So it's completely different.
She can stream the content, I think, then.
All right, that's it.
I thought one of your key takeaways would be pay your lawyer's bills.
Yeah. You're going to go after you?
Yeah, that's right. I think, one thing I will echo with Raphael is, law is changing, so it keeps evolving. Make sure that you are keeping up to date to the law. And I think one other key takeaways that I want to bring is the data localization. Shana has talked about it. Russia, how data needs to be stored in Russia and processed in Russia. I see this as a trend as well in different countries. In China, there's the new cybersecurity law that people have heard. There's a data localization requirement as well. So when your business expands in the new countries, do keep in mind that these are great costs to your new business. So make sure that you know what the laws are before deciding to go into the country.
So I think everything that Raphael said pretty much applies to India as well. It's like that. And a couple of additional points. So IP and works for hire concept is slightly different. So of course, go to a lawyer and get your contract vetted, especially if your IP is very important and you're outsourcing to India. Second is choose the right city or the right state to do business. So this is something that people tend to go completely wrong, in the sense that, look, Bangalore is like the tech hub of India, and the natural tendency of you will be to sort of come to Bangalore for any tech-related work, but it may not really fit your purpose, because we have state laws which are different and each state has different law. Very recent example, one client came from US and they wanted to start a global development center in Bangalore. They commissioned the whole thing. They built up the whole the campus and facility, spending millions of dollars, and then they realized that the kind of labor laws there do not actually help a smooth transitioning of the different shift that they're planning to do, in the sense that the breaks that you need to give in between was not sort of conducive to what they were planning to do. Whereas if they actually went to the neighboring state, they could have done it without any trouble. So, they just didn't the do the due diligence properly. And the last important aspect, which especially for people coming from the valley, is be patient. It's it's going to take a long time. Things are improving, but it doesn't work in the same pace.
Okay, well, interesting. Well, I'd say we're rather quick, which can be a bad thing sometimes. So generally, I would say it's important to be aware that Russia is civil code jurisdiction. So our approach to contract law is different. So there are things like duty of good faith in Russian law, which is completely absent in the UK or US. And that there are a lot of weak party protections. So when you deal and to think that you entered in a good deal, it might be rewritten by the court. And it's another thing that the court may rewrite a contract under certain circumstances. And also there are pretty complicated jurisdictional rules, so you may end up being under Russian law jurisdiction. So make sure that your contract was properly drafted, and you understand all the implied terms, etc. Then, tax compliance and personal data compliance, as usual, I guess it wouldn't be different anywhere else. So probably that's it. Not so many specifics. Well,
do you have any questions from the audience? Possible microphone, I think, would help.
WeChat Pay, and actually it's very powerful in China at the moment. But actually, I also noticed like Tencent, WeChat, Alipay, they're also extending in Southeast Asia, like Hong Kong, Taiwan. So I understood that also like different law practices compared to mainland China. But actually, a lot of my friends, overseas friends, told me it helped me cook very like a lack of living convenience. Just scan the QR code and very convenient compared to using Visa and MasterCard. So I want to know what is the hindrance of kind of implementing WeChat and Alipay in like Southeast Asia countries such as Taiwan, Singapore, Hong Kong, and so on and so forth. Thank you.
Okay. Very good question, and thank you for the question. I think it boils down to two important aspects. One is regulatory and compliance. Say, for example, in Taiwan, because of the history between China and Taiwan, it sometimes made it difficult for us to expand in Taiwan in terms of payments business. Because if you think about it, payments is about money in your own pocket, money in customers' pocket, right? If anything goes wrong, the government would be subject to a lot of negative press attention. And so a lot of regulators will actually pay a lot of attention when we're launching payments business in these countries. Secondly is the cultural difference. Sometimes when we want to launch a payment service in Southeast Asia country, right, the government or the regulators may not understand fully the benefits of launching these payment services in those countries. And therefore, sometimes it's an education process. That brings it to what earlier I said was engage with them, educate them, so that they're on board with you. I think those would be my answers.
And I just not to spend a lot of time on it, but I just want to really reiterate what Timothy just said. I mean, when I was at eBay, PayPal was a part of eBay. The issues that PayPal was experiencing at those times really are very much what was described here today. It's a matter of getting in front of regulators and understanding what their expectations are. And sometimes in markets where because of the convenience, as you rightly mentioned, there's an adoption within the country even before there's a formal presence. And so sometimes you have a customer base or consumers in that country when before you even walk in to meet with them.
Maybe one more question?
I'm Larissa from Brazil, from Pinheiro Neto, as Rafael. I have a question regarding Russia regulation on privacy. So as you said, the privacy regulation imposed the companies to store the information of the Russian citizens in the servers within the country. So then I have two questions, because we almost had the same problem in Brazil in the past. 2 years ago, the president tried to pass a bill on that, imposing the companies to have all the information within the country. And the first question, how do you track that a specific user is a Russian citizen? And the second question is, how did the market react to that, especially the startups? Because as far as I remember, 2 years ago, the US tech companies, they put a lot of pressure to don't allow this kind of regulations. So if you could tell us about this.
All right.
Thank you.
Thanks for your question. Tracing was a major issue because it was the first question which everyone was asked, how do we know that they hold Russian passports? So, and now generally people are identified through their, when they pay with their credit or debit cards, so they can clearly be identified, and also Russian IP addresses. So it's much wider than just being a Russian, but how else would you identify a person? Now, how the business reacted? Well, it was a very difficult year for the business, and it's very costly. I guess the major problem with our legislation is that we have the same set of rules for everyone. So a huge bank will have to the same compliance issues as a small startup. So I guess smaller companies won't like it because they won't have enough money to comply with rules, and it will affect the business. So it's something which is contrary to the desires or interests of business in general. Because what we see is like multinationals, they comply because, again, they have enough resources and the market is interesting for them. But for smaller companies, it's, of course, a nightmare. And even for small Russian companies, because they face the same difficulties. So expensive and inefficient.
Well, thanks so much for all the members of the panel. I think you not only collect a lot of miles getting here to this event, but having a freedom of stand, and that's even on Valentine's Day. So thanks a lot. That was very interesting.
Thank you.
Thank you.